Good afternoon. This is William Tincup, President of Recruiting Daily. It is a wonderful day today, and I can't wait to kind of get into this webinar. We've been promoting it for a while now, and we have a wonderful speaker who is extremely knowledgeable, and we're going to get schooled. We're going to get some education, maybe some answers to some of the questions that are kind of keeping us up at night. Key to all webinars, especially this one, is questions from the audience. We've got some great slides that have been put together, a lot of data, but it's always great to hear, your thoughts and things that that just you'd like to hear from. And if we can't answer them during the show, what we're going to do is we're going to try to kind of get all those questions together and then answer them after the show. So even if you don't get them in whilst we're on air, no worries. We're going to still try and answer those questions as best we can. All right. So today, Cannabis Conundrum. Let's go ahead and kind of introduce kind of the speakers, if you will. I'm going to be moderating, mostly color commentary and asking Joe questions. Joe, do us a favor and introduce yourself real quick.
Sure, William. Hi, I'm Joe Kenney. I'm the Chief Global Compliance Officer at First Advantage, and it's a pleasure to be with you today. I look forward to this opportunity.
All righty. So, William Tincup, I've been at the intersection of HR and technology for 20 years and fairly opinionated, which is both good and bad, I would tell you. But anyhow, there's me. So let's talk about the disclaimer that whenever you go to a compliance, event. One of the things that they all tell you is, "Hey, we're going to give you some knowledge. We're going to give you some opinions and advice, but always check with your local employment attorney. Make sure that you do that." And same applies here. Joe's going to give you some great things to think about, etc. But please don't use that as a replacement for just your local legal advice that you already have under advisement. So, housekeeping. Most of you have attended webinars before, so some of this is going to be a bit benign. If you are on the Twitters, please use hashtag #OurDaily if you'd like. And again, if we can't get to your questions, we'll roll those up and we'll try to get those back to you. The recording and the slides, most importantly, will be available. We say 24 hours. It usually happens faster than that, but within 24 hours, we'll get a note out to everyone of where they can get those. So without further ado, this is our today's discussion questions. Joe, why don't you start right here and take us through these 6 things.
Certainly, William. So today we'll be looking at exactly what is this cannabis conundrum. We'll look at what is the current public opinion and politics of cannabis, what is the difference between state law versus federal law, which states are passing these laws, and what about case law? I'm sure you'll all be interested in trending, meaning how do other leading edge companies balance their legal risk concerns with their commitment to a drug-free workplace? I can tell you that I've spent the last 3 months on many calls with our clients, helping them puzzle and think through their strategies regarding the cannabis conundrum. So you can move on to the next slide now that I've introduced the scope.
Absolutely.
Thank you. So let's start with the cannabis conundrum. I love the word conundrum because that's truly what I've been facing, and all of you who have workplaces to be concerned about, and you're concerned about safety, health, productivity, you're concerned too, and you're faced with the same conundrum. So how does an employer meet the objectives of their drug-free workplace program while also complying with federal law and guidance on medical marijuana versus the state medical marijuana, the legalized recreational, the decriminalization, and the laws concerning marijuana extracts or oils? And I'm talking about cannabidiol. And then we have to be a little concerned about the case law decisions, which are going a little bit south as far as I'm concerned, but not to worry quite yet. And we'll talk about those. How does an employer minimize its legal risks associated with cannabis use? How does an employer decide if they should take marijuana or THC off their testing panel? Or do they stay the course, not take that marijuana off the panel? Prohibit, permit, treat it like a prescription medication? Or should they be focusing on impairment versus use, fitness for duty, if you will? So, what is the current public opinion and politics of cannabis anyway? You can go to the next slide. Well, as you can see from this slide, public acceptance of marijuana is increasing. It's very evident to us all. 60% of the populations actually support medical marijuana, but now we have 9 states as of July 1st, with Vermont being added, that indeed have recreational or legalized marijuana laws. So 58% no jail time for recreational use is preferred, and support some of legalization. So you can move on a little bit there. The debate continues. Our new Attorney General, as of the new administration, has really added to the debate, if you will, has revoked the Ogden memo saying that prosecutors can indeed prosecute or should consider exercising their prosecutorial duties relative to marijuana charges. And we certainly haven't seen much activity in that, but the debate goes on for sure. It's important to define the terms here when we think of cannabis and marijuana. Cannabis, according to a 2017 report on health effects of cannabis and cannabinoids, was published by the National Academies Press and written by the National Academies of Science, Engineering, and Medicine. Now, this particular publication was a seminal and comprehensive look at marijuana as to whether marijuana is indeed medicine. And it really didn't have any big conclusions, suggested that research was needed. But one of the things that I particularly enjoyed about this report is that it did explain the difference between marijuana and cannabis. And even though they're used interchangeably, they're actually 2 separate entities. Cannabis is an overall term describing cannabinoids, marijuana, and hemp. And they're all derived from the same plant, which is Cannabis sativa. There's other cannabises as well. Products exist in various forms and are used medically, industrially, and recreationally, but for different purposes. We have to think about edibles, oils, a variety of smoked or vaporized substances, and also prescribed marijuana, which would be Marinol, Dronabinol, Nabilone, and Sativex. A word on Sativex. That's a sprayed oil that is actually THC, and it would really help us if that particular medication was available, because it would change the landscape a little bit, because the reason marijuana or THC is now on the Controlled Substances Act under Schedule 1 is because there is no medical use recognized for marijuana or THC at this time. If Sativex is approved in the US, that would shift the ground rules a bit, and we'd have to see what would happen. But again, it is not authorized yet for use in the USA, but in many other countries it is.
Quick question, Joe. It's always been the case that the discussion is about we need more research. We need to look into this further, and we need to see, especially the linkage between medical and usage. Have you ever been able to get a clear idea of how long something has to be researched? Like, are we talking a 100-year-old study, or are they talking about, well, we need 10 more years of really deep research with a lot of different studies? Like, what have you gotten any clarity on that at all?
Well, honestly, William, it has to get started first. All we had last year was the approval or recognition by the government that research may be done. In other words, we had a rulemaking, a Code of Federal Regulation rulemaking that basically said we're going to loosen up the criteria for making marijuana available for research studies. So until that becomes mainstream for researchers, it's really hard to say how long those reports are going to take.
Gotcha. Great.
Yeah.
Thank you for clarifying.
So let's define those terms I'm speaking of. Medical marijuana, legalized recreational marijuana, decriminalization, cannabidiol, and there's various other marijuana extracts as well, but we'll focus on cannabidiol a bit. So medical marijuana. These are the state laws which allow an individual to defend against criminal charges of medical marijuana possession if she or he can prove a medical need under state law. So we then have legalized or recreational marijuana. Those are the laws, policies making possession and use of marijuana legal under state law. We have decriminalization. Those are the laws or policies adopted in states or localities reducing penalties for the possession use of small amounts from criminal sanctions to fines and penalties. Now, this really comes from the ONDCP at the White House, which really is, so they're good definitions. They're used for the Drug Testing Advisory Board, and they're used in the drug and alcohol testing industry. Cannabidiol, or marijuana extracts, are low-level THC, non-psychoactive substances. They're the major cannabinoid in a plant. Medical uses are being claimed and explored. And a number of states, I just did a research project on this, have CBD laws, 18 of them. Most, however, are not directly applicable to workplace testing, but they could certainly impact on an employer's drug-free workplace program, only because they have to be considered. Do they apply or don't they apply? Again, most of them do not, but it can be a bit of work.
To the novice, Joe, you can separate THC from the rest of what would be in cannabinoid, right? You can make
Correct.
it. So
Correct.
you can actually for those at home, most of marijuana it contains many things. THC is, well, one of the things that gets you high, but there's other characteristics of marijuana that can get pulled out. And when you say CDB, what is that? I can't remember what the acronym means.
It's cannabidiol.
That's
and really, yeah, there's 113 active cannabinoids identified in cannabis, and CBD or cannabidiol is just one of them. But it's a major cannabinoid. It accounts for 40% of the plant's extracts, actually.
Right.
Again, being explored for potential medical explanations. Now, this is the CBD is the substance that is part of the concerns out there when folks have epilepsy or small children. I mean, that, and it doesn't have a supposedly psychoactive ingredient, and so there's a lot of interest in this substance.
That's
but
right.
It is illegal, by the way. It's still on the Controlled Substances Act.
That's right, because it's a part of marijuana or part of cannabis.
Correct.
Got it. All right.
Now, there's some pushback related to the evidence of long-term deleterious effects. 9% of those who experiment with marijuana will become addicted. So some people may think that's a very small percentage or not, but it still comes under the definition of addiction, the compulsive use of a substance despite ongoing negative consequences, which may lead to tolerance or withdrawal symptoms when the substance is stopped. You get some. Go ahead.
Yeah. Well, so do you believe it's a gateway to other drugs?
I do, and a lot of other folks do. But yeah. It doesn't matter what I think about that. True, I think all of that is really opinion and nice philosophical talk. I think when we're talking about marijuana in the workplace, when we're talking about cannabis in the workplace, we're talking about CBD in the workplace, what are we really talking about? We're talking about health, we're talking about safety, we're talking about productivity, we're talking about impairment. Is there impairment, which is a really difficult issue, and fitness for duty relative to the functions that that employee performs.
Right.
So I always bring it back to where we really have to be.
That's right. That's right.
So you see, as far as addiction to marijuana and other substances, overall level of confidence is high, to your point, asking me about whether it's a gateway drug. That would support that evidence right there. Adverse effects in this table would support that. You see there's not much about medium abnormal brain development, progression to other drugs, schizophrenia, depression or anxiety, and then you get back to high again. Diminished lifetime achievement, and that's a concern for productivity. Motor vehicle accidents for drivers, that's a high risk, and symptoms of chronic bronchitis, we're talking about health there. Lung cancer is low. That always surprises me, but there you have it.
That is interesting. Good gosh.
Yeah,
Well,
it is.
It also, depending on when this study was done, it also might, the edibles and some of the other distribution methods might, that might explain that. If you're,
Could be.
not smoking
Yeah,
it.
could be.
Okay.
Could be, because there's certainly a lot of other avenues for ingestion at this point. You've got vaping, you've got the edibles, you've got the tinctures. So there's even in smoking, I mean, 2 states, New York and Montana, don't even allow smoking in their marijuana statutes. Medical marijuana statutes, they require vaping or tinctures in the case of Montana, or edibles in the case of Montana. So you also have this pushback, and we've already been alluding to that due to the lack of medical evidence. Again, to be able to do that research we were talking about, you need a DEA license to conduct that medical research. And by the way, the marijuana or the cannabis has to be available so that it's controlled growing, which is a real issue. So the trials really are delayed. So is it going to be that 10 years you asked about, William? Is it going to be 20 years? I don't know, but it's really important that we do know whether marijuana is medicine or not and put some controls in. But unfortunately, we're operating in the dark here. But there is this policy shift from the DEA in 2016 that I applaud, which is to foster research that, and if that happens, and I haven't seen that much yet, a little bit, we'll see a change or a shift in the equation. Again, that report is a very important report as far as I'm concerned. For anybody who wants to know anything about the medical or health effects of cannabis and cannabinoids, take a look at this report. It's worth the effort. There's still many scientific knowledge gaps about marijuana risks and benefits. Again, they're absolutely right. Research has been stymied for way too long, and that's unfortunate for us all.
Right. Sladika, you brought things back to the compliance side of things, risk. And a question just kind of came in about alcohol, how this kind of compares to our kind of our approach to alcohol in the workplace.
I really see them as 2 separate issues. I try not to pair them. Because with alcohol, you can determine impairment. With marijuana, you can't determine impairment. There's no impairment test for marijuana. So you have a subjective versus an objective situation when you're talking about alcohol versus marijuana. Yes, there's some of the same symptoms, there are some of the same risks associated as far as safety, health, and productivity, but they're different in other ways. What you have is maybe less productivity with long-term marijuana use. You may have a slowing down. It's the signs and symptoms are just plain different. And I think that has to be really understood. So I try to stay away from that and comparing the 2.
Right. I can see that. Okay. Good. So the report, you got the link. That's fantastic. let's go on to our next slide. So it's state law and federal law. Okay.
So what are we talking about here? Well, we're talking about how we have a U.S. federal law that conflicts with state law. Now, up here in the state of Maine, as of yesterday, we had the legalized or recreational marijuana law basically approved or passed by the Senate, and probably within 10 days it'll become law, signed by the governor, probably going to withstand a veto according to those pundits speaking about it. And one of the things the governor is saying is, well, he's still concerned because, of course, the state law in marijuana would indeed conflict with the federal law, because under federal law, marijuana comes under Schedule 1 of the U.S. Code, which prohibits tetrahydrocannabinoids, which includes marijuana. And medical marijuana, by the way, is not a legitimate medical explanation under DOT, but Marinol is. Now, there's a prescription for Marinol, so keep that in mind. And effective January 13th, 2017, and I've been alluding to this, the Department of Justice Drug Enforcement Administration published a final rule in the Federal Register, which included extracts of marijuana, such as cannabidiol, under Schedule 1 of the Controlled Substances Act. Now, it's highly improbable that an employer is going to see a positive marijuana THC drug test based on cannabidiol, because generally speaking, it's going to really not come up to the cutoffs that are usually used for marijuana testing, or THC testing, which is usually 50 nanograms per milliliter. So unless a company has a zero tolerance or some other cutoff that they're using. So actually, this was news in 2017 to add this. It still has to be considered, which is why I did that research project on cannabidiol, to make sure that our MROs understood what those rules around cannabidiol are.
Let me ask just a quick question. With the money, I'm thinking of Colorado in particular right now. With the money that's at play, do you think that the states have even more of a vested interest to fight for, keeping what they have, let's just say?
Absolutely. In fact, one of the comments this morning on the news in Maine regarding Maine's recreational legalized marijuana law was $23 million in revenue to be generated. 23. So that's a lot of revenue, and it's really being promoted. So yeah, there's a vested interest in revenue to the states for sure, enough to fight for this.
Right. Yeah.
By the way, there's costs too. We need to look at the flip side. There's costs as well. And it really imposes a lot of pressure on employers, because those in the audience today are going to have to worry about, well, how to manage this. Productivity, health, safety. And sometimes we lose sight of the costs, legal risks, all of those things.
Right. Right. Okay. This is fantastic. It's almost like as I was thinking about gambling, and when gambling became popular, casinos in particular became popular. Some states jumped on the bandwagon and some states did not. So,
right.
Very funny. All right. Which states are passing which laws? All righty.
All right. So what about these state laws? Again, you have to look at what is permitted in a particular state law regarding whether it's smoking, it's vaporized, whether edibles are allowed, what's the rule on cannabis, if anything. Go to the next slide and we'll talk a little bit about the numbers.
Okay, good. There we
Please.
go. Yep.
So we have 30 traditional medical marijuana states and DC and Puerto Rico right now. I mean, that's up from 27 last year at this time, in February actually. 18 non-traditional, although some do permit smoked and some oils, decriminalized, and Guam and Virgin Islands for decriminalization, 18 low-level THC laws for the cannabidiols. Again, that 8 legalized recreational use. Now, Maine's law has been in effect, of course, as of last year, but then it only became, the employer provisions only became applicable in February of this year, 2018. And now with this amendment to the legalized recreational law, the distribution system will be in place. So we'll have 9 states with these legalized or recreational use statutes, including Vermont in July, which will be the first state with legalized recreational law that actually went through the legislature from the legislative process versus a
Voting.
ballot measure or a constitutional amendment as part of the voting process. Yes, William, yes.
Right.
So it's a very interesting process to see how this is evolving. And with Maine, recreational marijuana, has been troubling because, of course, now we have the distribution system almost in effect once it gets signed, assuming it is signed and nothing different happens. By the way, it was interesting to watch the news this morning because one of the legislators was commenting that they made lemonade with lemons, but they did the best they could. And the other legislator on the news this morning commented how pleased she was with the bipartisan effort and that it was government working at its very best. So it was a pretty interesting way to look at this law.
Yeah, that is just wonderful political spin right there.
Right. And I do want to say, too, about Maine, we also had a law pending on impairment, really a major overhaul to the drug testing law in Maine. And the reason I'm talking about Maine is not only because I live in Maine and work in Maine, but also when I'm not somewhere else. But in any event, it's important to me because Maine has had some very innovative ideas about fitness for duty, about impairment, about training concerning impairment detection. Now, I just want to say, though, that law is now dead for the moment, meaning it's not going to be taken up probably this legislative session. Needs a lot of work. It's a very long statute with very cutting edge ideas, and I think it's going to probably take a lot of reworking. But I think we need to watch Maine as to see what happens with Maine, because if Maine does get this statute in place at any point in the next year or two, we'll see other states mimicking Maine, because that's really what happens. That's what happened from the very beginning in the medical marijuana laws as well, where
Nice.
one state will kind of mimic another state,
Right.
which makes sense.
Yeah. Right. Especially what works, right? Exactly. Wonderful question, Joe, from Natalie, and she's asking about Marinol. And the question is, what makes Marinol a valid prescription, but other marijuana options invalid?
Just a legal construct. Because it is a prescribed medication, it's gone through the FDA approval process. It's then outside the controlled substance. It has medical use, so it's taken outside of the Controlled Substances Act because it's legitimately prescribed.
That's interesting. And yeah. What's the prescription for? Is it usually epilepsy?
Oh, I think it can be for a variety. Our MRO would be better able to answer that question, but it really could be for any medical symptoms that would be for any other medical marijuana use, depending on the state statute. Yeah.
Gotcha. Another wonderful question from Ariana. Can you clarify the low-level THC laws?
Okay, well, there's 18 of them, and they're all different. Most of them are either pilot studies, they're directed at children, a very small subset of the population. They're very different from one to each other. Again, there's only a few of them that could have any impact on workplace. So it's not a part of the equation that I worry about a great deal, but it's still good to know that they're on the books.
So let me do a little quick time check. We're 30 minutes in. We've got about another 15-ish slides. We're getting some great questions from y'all. Really appreciate it. It makes the experience better for everyone. And in fact, I'm going to get one more in, Joe, before we get to the next slide.
Sure.
This is from Wayne. And it's in Maine, is it legal to test for marijuana in pre-employment drug testing?
Absolutely, Wayne. Thank you so much for asking that question, because I've spent the last 2 months trying to get accurate information out there on Maine. Maine marijuana is included in the list of testable substances in the state of Maine. At the end of March, the Maine Department of Labor that administers workplace testing in Maine published a guidance paper that as much as says that, states, and I have blogs on this too on the First Advantage website, that basically says, yes, you can test for marijuana in Maine as long as you have an approved policy approved by the Maine Department of Labor. In Maine, there's a list of testable substances, and an employer in Maine who is seeking to have an approved policy under the Maine Department of Labor can choose which substances it elects to test for. So in other words, a Maine employer could decide not to test for marijuana, but there's no prohibition whatsoever against them testing and for marijuana in the state of Maine. It's important to always monitor the website in the state of Maine, the Department of Labor, under their substance abuse testing program, to get all the latest news. And I'd also say that there were several publications out there in the popular press that really had created some confusion, and apparently an official in the state of Maine, and I don't know who the official was or anything like that, but apparently led some folks to believe that they couldn't, that employers could no longer test for pre-employment for marijuana in the state of Maine. That's not true. Not. So
Gotcha.
that's my
Great question, Wayne. Thank you so much for asking that. Okay, let's go to the next slide. Okay.
So each of these state laws vary significantly, whether you're talking about cannabidiol, the CBD laws, whether you're talking about medical marijuana, whether you're talking about decriminalization, whether you're talking about recreational legalized use. All of these laws vary a great deal from state to state. You need to look at who the law applies to, the quantity of marijuana permitted. You need to understand the distribution system. Like I said, in Maine here, we had, the only way you could exercise a desire to use marijuana in the state of Maine up until this latest development, you had to grow your marijuana yourself. And now there'll be a distribution system and controls, and there'll be a limit on the number of plants that an individual can grow, as I understand it. It is an 84-page report or bill regarding the marijuana, legalized marijuana law in Maine. So I haven't, since it was just available this morning, I haven't studied it yet, but it'll be interesting to see how that all is implemented. And of course, liability protections vary from state to state as well. The statutory requirements for authorized use, meaning what illnesses, what medical conditions would be covered under the statutes, and those do change from time to time. PTSD was just added in a couple states or after the initial medical marijuana laws, and you do see with the state laws generally an evolution over time and amendments to laws as new information becomes available.
Right. Okay. Oh boy, I know you've been chomping at the bit to get to this. So
here I am at my state law. Oh boy, I'll try not to bore you all to death here. So let's talk about the historical medical marijuana case law. You know, I don't want you folks out there to forget about Gonzalez versus Raich, even though it was a case where, in my opinion, the U.S. Supreme Court didn't go as far as it could regarding marijuana. It was still a very important case. It started out as Ashcroft versus Raich, and then it was changed to Gonzalez versus Raich. And really what this case was all about was how medical marijuana would be interpreted relative to its use in the workplace, and how ADA and Americans with Disabilities laws fit into this as well. So basically, for me, the big takeaway was that medical review officers could verify drug test results as positive for marijuana, even if the employee was using marijuana under state law, without fear that by doing so, they were ignoring medical authority, making such use lawful. So this was a good case, really, for employers, employer friendly, if you will. That was followed by Washburn versus Columbia Forest Products. It was a state law case in Oregon, and the trial court ruled that employers might have to make reasonable accommodation for disabled workers invoking the protection of the Oregon Medical Marijuana Statute due to the Oregonians with Disabilities Act. And law. And the court also ruled that Washburn's use of medical marijuana does not automatically entitle him to accommodation, and that the employer could consider whether or not that would be an undue hardship under the reasonable accommodation dance, if you will. Now, interesting, the trial court's decision was overturned in 2006 and held that the plaintiff did not show that he suffered from a statutorily covered disability and that the employer had no statutory duty to accommodate his physical limitations. So it was an employer-friendly decision. Then we had Ross versus Waging Wire. And in that California case, a seminal case really historically, there was an initial case that kind of didn't go our way. And then what later happened was that the lower court's decision was upheld on an appeal to the California Court of Appeal, and it held that employers have legitimate interests in not employing persons who use illegal drugs. And the court further held that such use has resulted in, among other things, and this is important for you all out there, increased absenteeism from work, diminished productivity, greater health costs, and increased problems with respect to safety in the workplace. Now, that is still good law. So, even in California, we really need to keep that in mind. Further to historical case law, if you'll mind moving along for me, please, William. Yep. We have Johnson versus Columbia Falls Aluminum Company. We have the Emerald Steel Fabricators versus the Bureau of Labor and Industries. And I talk about these cases as kind of twins, if you will, because each court held that an employer was not required to accommodate an employee's use of medical marijuana. Notably, the plaintiff in the Johnson case was an applicant, and the plaintiff in the Emerald case was a temporary employee who was refused permanent status after Emerald learned that the temporary employee was a medical marijuana user. So this is a friendly, an employer-friendly case for sure, no doubt about it. Now, a word on accommodation. I've always suggested, and certainly not legal advice here, even though I'm an attorney, you really want to check with your own legal counsel, but really considering the accommodation dance, the ADA requirements is a very good idea, regardless. So we'll move on to Coates versus Dish Network, which was the Colorado Supreme Court's decision in 2015. Another seminal case under the plain language of the section of Colorado's lawful activity statute. Basically, the employees who engage in activities such as medical marijuana use that is permitted by state law, but unlawful under federal law, are not protected by the statute. So really the Court of Appeals decision was indeed upheld. And we also had, by the way, Cassius versus Walmart stores in 2011, although I didn't mention that. And the court held there that Michigan's medical marijuana law says nothing about private employment rights, but only provides a potential defense to a criminal prosecution or other adverse action by state. So this is the historical employer-friendly section of my discussion here. So, William, you're trying to get a word in, so go ahead.
Well, I'm trying to get some of these questions in.
Okay.
Okay. Two of them that I really want to put in front of you real quickly. Are you seeing any trends related to employers relaxing their employment screening standards?
I can tell you that I've had quite a few discussions recently about whether to take marijuana off the panel or not. What I've found is that very few employers actually are taking marijuana off their panel. That's the
Interesting.
biggest trend that I'm seeing. And to me, it meant most of our employers are staying the course. When I talk about trending, there's a trending slide, kind of way up there, but only 78.40% do not accept medical marijuana. And really, as far as that taking THC off their panel, only 25 of our clients, some with multiple locations, but only 25 of them have actually taken THC off their testing panel. So what we're looking at is employers mainly staying the course.
Right.
So, what's the answer here? Yeah, what I'm seeing is more discussion and fresh looks, which is always good in any area, than any massive changes.
Right. And that question comes from dear friend Josh Akers. So thanks for that question, Josh. The second question that I wanted to kind of get in front of you was, with the talent shortage, do you think employers will have to adopt pre-employment drug policy to fill position, to adapt? Do you feel like they'll have to adapt it because of shortage of talent?
Well, I'm certainly seeing the popular press speaking a lot about that, HR consulting firms, and I was actually interviewed by CBS Money Watch on that topic. And that is not what I'm seeing. I'm seeing employers staying the course based on my subset. Certainly employers are looking at that, but I almost wonder what's driving it. I realize that we're at a high employment state, but you still want productive workers. You still want to make sure that the folks that you have working for you are going to be able to perform the functions and meet your productivity expectations. So, massive changes to pre-employment policies, relaxing, not testing for marijuana, to me is not the best idea I've ever heard. But again, it's also a risk thing. Employers need to talk this over with their and how many what their hiring needs are. There's a lot of individual considerations that have to be taken into consideration.
Gotcha.
So
Well,
you're going to see some unique things there.
Right. All right. So let's get on to the next one. Okay. 2000.
So yeah, in 2016, we started seeing things go a little bit south, away from employer-friendly cases, wrong direction, but nothing really horrible, just not as friendly as they used to be. And remember, we still have that historical case law. But in 2016, we had the Connecticut Employers Union Independent, where the court held that the public policy does not require termination of a state employee for smoking marijuana during work hours. In this case, it was a maintenance worker that was discovered smoking in the state van, and the court vacated, including the Connecticut Supreme Court, on public policy grounds. So basically, adverse action was not permitted. In Burbuto versus Advantage Sales and Marketing, and by the way, there's a corollary case in 2017, meaning the case moved forward. But this was a great case decision, and basically because the court said there was no duty to accommodate medical marijuana, there was no private right under the law there in Massachusetts, and there were no public policy prohibitions. But again, this was kind of changed in 2017, and I'll talk about that. Garcia versus Tractor Supply in New Mexico, the employer had no duty to accommodate an employee under the medical marijuana statute for medical marijuana, which provides criminal protections. It's silent on employment protections, and the court said there was no violation of the New Mexico law on public policy to terminate based on a failed test. And then we had the Montana Cannabis Industry Association versus Montana. That was a pretty good case where state law limiting the scope of and availability of medical marijuana was upheld under the court, under the act. So that was a more positive or employer-friendly case. And then we have the next group of cases that are still pending, basically. So we have Rhode Island, where we had Callahan versus Darlington Fabric Corp. And I love this decision. The court's decision started with, "I get high with a little help from my friends" by the Beatles, 1967. That's the very next phrase after decision in this court decision. But this particular court decision, in my mind, was pretty troubling. But the trial is pending, essentially. Under this particular case, Medical Marijuana Act contains explicit employment protections, prohibits discrimination on the basis of patient or caregiver status. Let me just explain that's what's happening here with these cases, these three cases I'm talking about now, is that the courts are looking at other legal authority, meaning discrimination, ADA, and they're saying that perhaps the Controlled Substances Act, or the federal law, is not preempted relative to these discrimination laws and other laws. So this is troubling, because what we're looking at really here are new theories of litigation that are now being explored. And so anyway, Rhode Island at this point with Callahan is essentially still pending, and with the trial unsure as to when it's going to happen. And then we have Massachusetts, and that's Barbudo versus Advantage Sales and Marketing. I mentioned that was a 2016 case, still ongoing. In this case, the statute doesn't include explicit employment protections. No punishment under state law, protection from state prosecution and penalties shall not be penalized under Massachusetts law or any manner, or denied any right or privilege. Doesn't require accommodation of any on-site medical use of marijuana in a place of employment. However, what the court held was that even if there's no explicit employment protection in the medical marijuana law, there are indeed possible protections under other state law. And in this case, it was the handicap discrimination law. So that case is still pending. The court reversed that employer-friendly decision that I mentioned in 2016 a few minutes ago. And what we have now is essentially a motion to dismiss that's pending, and it's possible there'll be a summary judgment that might come about. So with the motion to dismiss, so for those of you who don't know, that means that no claim has been established. So that's pending, and the summary judgment said the court would say, well, on the facts, we find for the plaintiff or the defendant pending. So that's kind of where we are with that one. So it's still pending. We don't have anything definite yet. And last, Connecticut is the most difficult, the most challenging. The court just flat out in Noffinger basically stated that there's no federal preemption of the anti-discrimination provision. And that's all there is to it. And there's no explicit employment protections in that case, in that state either. So this Noffinger is the most troublesome of those three cases. We're watching it. It's still pending. There's basically cross motions by each of the parties, and we'll see what happens. So these are under watch at the moment.
Right. Well, let's go ahead and get to trading.
So trending, what do we do about all of this? What do we do about this? And what are our other companies doing? I think I already mentioned that only 25 of our clients, some with multiple locations, do not include THC in their testing panel. And there's currently no accounts with an address in Maine. And this goes to, I think it was Wayne's question about whether or not whether or not marijuana for marijuana testing in the pre-employment for pre-employment was prohibited in Maine. And this created a whole lot of confusion up here for employers and also for multi-state employers. But again, we've had very few clients, even after all of that Maine flap, actually take marijuana off their panel, mostly staying the course. So if you look at this percentage, even if you just look at medical marijuana, 78.40% don't accept medical marijuana. And now you'll see a little bit more leeway as far as acceptance or exceptions in the legalized or recreational states because there's a little more risk there. And again, that's very individualized by the employer and their legal risk tolerance.
Okay. Let's see here. Let's get to the next slide. We're about 8 minutes out, and I think we got about 4 slides left. So we're doing well, but we also have about 9 questions queued up. So we'll do our best, Joe.
All right. Well, I'm not going to read slides to you, but we're going to just kind of summarize here so we can get to those questions. But I just want to say it comes down to this. The cannabis conundrum is a complex issue. My overall suggestion is for employers to stay the course. Not knowing whether an individual has marijuana on board, to me, is a risk in of itself. But it really is an individualized decision, employer by employer. It absolutely is. And employer has to look at their risk tolerance and really talk it over with their attorney, talk it over with their leadership, and really decide what's best. And so really we're at a point, and I think at a crossroads, where employers should take a look at their policy, look at what they're trying to achieve with their drug-free workplace policy, make sure you're engaged with an attorney that is really familiar with your organization and with drug testing in general. And there's some very good firms out there that can help with that. Which brings us to policy language, and you're going to have these slides, so I'm not going to read this to you, but there are a number of things, if you'll go to the next slide, William, that should be considered. And I just set out what some of those concerns are. And I think we're going to go to questions instead, but do go to that best practice slide, please, in the interest of time. So what my suggestion from a best practice is, I mean, I'm an attorney. I've been the chief global compliance officer at First Advantage for 2 years. I've been in this business since 1989 for drug testing and now all the other screening products that we have. And what I say is, from best practice, consult with your legal counsel in the context of your organization's risk tolerance position and legal risk mitigation strategy. Include clear information about your organization's position on marijuana and all the different variations thereof. Watch these state and federal laws carefully. Follow my blogs, please. Read our FADV e-newsletter. Consider Equal Employment Opportunity Commission's guidance on individualized assessment. For those of you who do background screening, you're probably very familiar with individualized assessment. It's a good tool for marijuana as well. Consider your job functions. Make sure you understand the scope there, and don't overlook the Americans with Disabilities and federal law, handicap discrimination, and the state law implications, and monitor state and federal rulemaking and regulations and guidance. I've given you some sources and resources, things that I've read, that I keep, how I keep up on this. Some very good books on the ins and outs of this, that, you know, so you can make your own opinion with your own legal counsel as well.
All right, so we've got 6 minutes in. Let's just try and get through as many of these as we can. Question number 1: how does an employer manage Marinol issue, the Marinol issue? Meaning, if someone tests positive above, as it looks like, 50 milligram or milliliters, are employers safe to take corrective action up to and including termination?
Well, I mean, it's like handling a prescribed medication. You're going to look at if it would be the same if it was an opiate prescription or any other legal prescription. You're going to look at you're going to definitely want to look at what functions that individual performs. You might want to do a fitness for duty evaluation with a local physician. Make sure that the individual is indeed safe to do the work if they're in a safety sensitive, and look at that as well. So it's a legal risk tolerance. It's really for your attorney to look at how you want to handle that particular situation, but it'll be very similar to how you handle prescribed medications, as well.
Excellent. Next question is, do you know of any drug tests for THC that are able to better determine and dose of use recreational versus habitual?
No, in short.
That was by Heather, by the way. Okay.
No. You really can't determine one from the other for sure.
Okay, good. Let's get to the next question, which is from Ariana. Does First Advantage MRO consider medical marijuana licenses as acceptable in legalized states?
It depends on the company's policy. So what we have is a medical marijuana directive, and the employer client tells us how they want us to handle marijuana in their particular state, which makes absolute sense because it is indeed your policy.
Okay, good. That's fantastic. And then the next question by Bernard is, have HIPAA implications been explored or discussed with any of the examples you mentioned involving medical marijuana?
No, HIPAA doesn't apply to workplace drug testing is a position that I have always taken, and the industry overall has taken as well. It really comes outside of HIPAA.
Gotcha. Can an employee be held responsible if an employee purchases marijuana as a client gift in a state that has legal marijuana and expenses it, even if the employer did not know what the charge was for until after the expense was reimbursed? What a great question.
Well, that is a great question, and it's multifaceted. I think that's when I'd be calling up my attorney, frankly, and really try to figure out what to do about that. That's kind of a mess. You've got, you've got the laws regarding money. I mean, even the banks are having trouble with the whole issue of marijuana sales and whether they can take money in. And really, many of the marijuana distribution businesses are cash driven because of the shyness, for good reason, of the banks to process the marijuana, from which is, of course, illegal under federal law, through their banks. So it's kind of similar to that question. It's an interesting question. I'll have to think about that.
Yeah, and ask your attorney.
Yes, and ask your attorney.
Ask your attorney.
I might ask mine.
Hey, that was a great question. Thank you, Kristen, for that question, by the way. All right, next question is, let's see here. Do you believe that employers are holding off from removing marijuana from testing until they see how states will vote in legalizing marijuana?
I don't. I believe that employers right now are responding to articles in the popular press and the fact that it is a high employment time in our country's history. That's what I think is driving it.
Right. Well, we are right at time. I want to give you the last kind of minute to say any final things that you need to say, and then we'll close everything out.
Well, it's been a pleasure spending the last hour with you. I so appreciate the opportunity. I hope to keep speaking with you through my blogs and through our FADB newsletter, our First Advantage newsletter. And I hope to have an opportunity to update you again at a later time. Remember, I did this webinar for First Advantage in February of 2017, and a lot changed up to this webinar, and it is a real on the move tsunami, if you will, of information. So stay tuned.
Awesome. Thank you so much, Joe. Thanks to First
Pleasure.
Advantage. And also thanks to the wonderful people that showed up and asked really great questions. Again, you'll get the recording within 24 hours or so. And everyone have a wonderful day. And thank you.
Thank you. Thanks, everyone.